In their long campaign to discredit the Mueller investigation, the president and his allies have been trying to make the case that the special counsel struck out on collusion, finding no evidence of a criminal conspiracy between Russia and its agents and the Trump campaign. And that's why Mueller is investigating obstruction of justice, the argument goes, as a kind of backup plan. Witness this tweet from August. Where's the collusion? They made up a phony crime called collusion. And when there was no collusion, they say there was obstruction. But tonight, NBC News confirms the president's legal team is finally preparing answers to a list of questions submitted by the special counsel. And according to NBC's source, those questions are squarely focused on whether the Trump campaign colluded with Russia to illegally subvert the 2016 election. To help understand this latest development in the Mueller probe, I'm joined by former Watergate prosecutor Jill Wine-Banks and former U.S. Attorney Joyce Vance, both MSNBC legal analysts. Joyce, maybe I'll start with you. What's your reaction to this news?
I think that there's an interesting divide here, Chris. We notice that the president is being asked to respond, or perhaps his lawyers are being asked to respond in writing to questions about collusion. But apparently Mueller is still seeking an in-person interview with the president on the issue of obstruction. And that's good indication that both avenues of the investigation are still alive and ongoing.
Yeah, what do you think, Jill, about both the fact that they appear to have agreed written questions, which is fairly anomalous, but also that those written questions are about the sort of heart of the collusion matter?
I'm very pleased that they're about what I would call conspiracy, not collusion. There is no such crime. But I am disturbed that it's so clearly being drafted by his lawyers. That's not an answer. Obviously, he will have to submit them under his name, and he will be responsible for them. But the fact that he's being protected from answering the questions himself says that he can't be trusted to answer those questions about conspiring with the Russians or any other foreign power. So that's disturbing. And I'm also very happy to agree with Joyce that I'm glad that the conspiracy to obstruct remains an active investigation.
Well, Joyce, and that to that point about not having given up on in-person interview on that, and again, these negotiations, we basically get one side of this because I don't think the Mueller people are talking. The reporting we get, I think, tends to be from the White House. I think that's the source of much of the word we've gotten, that they were only interested in obstruction, which now appears to be not true. CNN saying the two sides have still not come to agreement on whether the president will be interviewed in person by investigators probing obstruction of justice. I guess what is the sort of calculation here, and what is the timeline ultimately in forcing that issue or not?
So, you know, it's interesting that Mueller at one point in March threatened the president's lawyers, saying that if the president wouldn't come in and submit voluntarily to an interview on obstruction, that he could subpoena him. I think it's unlikely he would have made a threat like that if he had not had permission from Rod Rosenstein. But as you point out, everything that we know about this seems to be coming from the president's team. It's coming through their filters. It's their view of events. And so we have to be very cautious and recognize that there may be an entirely different side of the story from inside of the special counsel investigation.
Joe, what's your thinking about when you go to the, let's say, so you've agreed to this sort of limited inquiry, right, where you're going to give them written questions, they're going to write them back. You know they're going to come from the lawyer. You're not going to, like, catch the witness, right, in a moment. What's the point of that from an investigative standpoint in terms of what knowledge you have and what you're trying to do with those questions?
It's nowhere near as good as having an in-person interview where the witness has to answer extemporaneously and is thinking on the spot. And as we know from past experience, the president is very poor at answering questions like that. I think that there is a limited, you know, going back to this limited thing, during Watergate, it was a limited, modified hangout, which was being suggested as part of the cover-up case. And that's sort of what this is. It's a limited, modified hangout where the lawyers are going to answer questions in legalese and very carefully. They're doing it based on documents that have supposedly already been given to Mueller, so that it's a very narrow kind of investigation right now. And it won't really provide much, but it will limit their ability to wiggle out of certain things later on, because once they're committed in writing, they can't change what they want to interpret things as. And that's what they've been doing up until now, is they sort of keep spinning in different ways.
Joyce, you're nodding your head. So did you agree that that's the sort of chief kind of prosecutorial or investigatory function of this set of questions?
Jill's absolutely right on both points. It would be much better to talk to the president in person, but this written questioning will keep the president's team from continuing to move the goalposts. Right. And if they're asked in writing, was the president aware of ongoing contact with Russia during the campaign? And if he responds no in writing, if Mueller has evidence to the contrary, then it will be impossible to walk that back.
That strikes me as a sort of interesting part of this, like putting a bunch of stakes in the ground, since they have been so used to pulling those up and moving them around. Final question here, Jill. Interesting filing in civil court in response to this lawsuit from the DNC and two donors about the hacking, which is the Trump campaign basically saying that exploiting hacked emails is protected under the First Amendment. It's even stolen information. If you disseminate it, it's in the public domain. It's a First Amendment right. It can't be illegal. What do you think of that argument?
I'd rather be on the other side of that argument. I don't think there's any logic to that at all, and that you cannot use the First Amendment, which he is so free to attack. I mean, his attack on the press is so virulent and so unfair that for him to say, I have a First Amendment right to do all these things is just, it's absurd, and I don't think it will fly.
What do you think, Joyce?
You know, I tend to think that Jill's right on this one, and even if she and I are both wrong, there are plenty of crimes available around receiving stolen property and the transfer of internet-based information. Mueller doesn't have any trouble here. If the facts pan out and tend towards a crime, there won't be any trouble finding one that fits.
Right. If the facts turn out to be the only thing they do is disseminate them, then that's the end of the chain. But likely, if there's something to prosecute there's something more in terms of the transfers of ownership or advance warning or being a sort of party to the conspiracy that's already been charged in federal court.
Right. Exactly. There would almost have to be a conspiracy here to create this notion that the emails were hacked and then sent on.
All right. Jill Wine-Banks and Joyce Vance, thank you both.